understand constitutional legal provisions, just like for any other sector, the legal framework is the fundamental framework in which all governments work, whether it is a state government, central government, Jilla Parishads, or municipal corporations or Gram Panchayat. They have to work within the framework of the laws, and the highest law is the constitutional law. The provisions in constitutions govern everything, whether it is a relations between the states and state, whether it is a sharing of revenue between state and states, whether it is health sector, labor sector, industrial sector, uh, and order, everything gets governed primarily by the constitution. And then based on the provisions in the constitution, we have different laws, and then for and policies, and all this total legal framework governs everything in the country. Anything that is done by any government or anybody or any entity which does not conform to the constitutional provisions is treated as unconstitutional, or if it is not as per the legal provisions, it becomes a civil case or criminal case, and the person violating the legal provision is punished. So when we talk about the water resources management in our country, we must understand the framework within which we are working. And it is all the more important for water basically because water is a dynamic resource. Unlike mines, where the mines are located in one area, so that is a resource located to that area. Water is a dynamic resource which is always in motion. It moves from one state to another state. It moves from one tributary to the main river to the sea, so on and so forth. And because it then becomes a shared resource, it is all the more important framework for regulating, governing, developing, and managing this resource. And all these issues have to be based on the constitutional provision. So I will start with my presentation. Again, if you feel like asking any question, please submit it through the chat window. And after the lecture, I will answer. Okay. Let me tell you that the morning session was quite interesting. Afternoon session is also very interesting. The only thing is because it is related to the legal provisions, which is a kind of a dry topic, and it is after lunch. So I'm sure you will all be attentive throughout the session, and I will try my best to make it simple. And even though the slides may be slides may have quite a bit of text there, I will only talk about the things which are important so that it is easy for you to understand. In the morning session, we saw that water sector is a very crucial sector, and we need to have a proper rule for its distribution, use, and management. A resource which is available in plenty and demand is less, there is no issue. But in case of water, it is other way around. There is a very heavy demand and supply is less. The distribution is uneven. Fundamentally, water is a state subject. That means in our constitution, the primary responsibility of creating laws, creating regulations, developing distribution, and other things of related to water are being given in the authority of state. So basically, state government has a primary responsibility for use and control of this resource. Okay, and this responsibility is discharged by the state government through its various departments like Water Resources Department, Command Area Development Department, Rural Development Department, so on and so forth. So what is the role for Government of India? If water is a state subject, then what is the role for Government of India? At the central government level, we have Union Ministry for Jal Shakti. Earlier it used to be called Water Resources, but now it is called Jal Shakti. And this ministry has two departments, Department of Drinking Water and Sanitation and Department of Water Resources, Rural Development and Ganga Rejuvenation. Now, at the central level, at the national level, this ministry has a responsibility of framing general policy on water sector as a national resource, as well as giving technical assistance to the states. it also oversees regulation and development of interstate rivers. So obviously, if the water is a state subject, what will happen to the rivers which are interstate? And there obviously there will be some differences, there will be some issues. So the responsibility of overseeing the regulation and development of interstate river has been given to the Government of India. At the Government of India level also, there are various ministries like Ministry of Urban Development, which looks after the urban water supply and sanitation. Then there is a Ministry of Drinking Water and Sanitation, which looks after the drinking water of rural area. Ministry of Power, which handles hydropower. Ministry of Environment and Forest, it handles pollution aspect of the water resources. Ministry of Rural Development, they handle watershed development programs and command area development programs and so on and so forth. Then there is a Ministry of Agriculture also, which is mainly concerned with the use of water for irrigation purpose. So if you see that for like for any other sector, there are three fundamental pillars which govern that particular resource. So in case of water resources also, there are three things: legal provisions, that is law, policies, and institutions. Law is framed by the parliament and the state legislative assemblies based on the constitutional provisions. The policies are also framed by the respective governments, which is basically a statement of guideline or statement of in principle statements as to how the water resources will be managed by various levels. And then there are institutions like ministries, departments, corporations who actually do the work on ground based on the law, based on the legal provisions and the policies. Now, as I said, for any sector, constitutional provision is the main basis for legislative and executive framework which govern the use, development, management of India's water resource. And where from these constitutional provisions have come? They have not come in 1947 immediately. That just we, our constitutional writers and constitutional framers sat together and then they wrote. No, it has a long history. Typically, water law as of now is derived from ancient traditions, local customs. British ruled our nation for 150 years, so British common law had a lot of influence on it. Then all of you might be knowing that before independence, there was a Government of India Act in 1935, which was implemented in 1937 onwards. There were many provisions pertaining to the responsibility of state government, central government. And today's Constitution of India is drawn largely on the basis of Government of India Act 1935. And then there were some modifications, additions with to that to make our Constitution of India. So these provisions have a long history and long tradition before they came into Constitution. Now, if you see the legal development in water sector, it can be divided in three parts. Before 1921, at that time, it was a British government. Everything that was done by the British was for the benefit of Britain. So at that time, everything they planned, whether it is irrigation work, hydropower work, it was only if it is going to be a beneficial to the Britain as such. It was not with the beneficial of the Indian population. So that's why before 1921, all irrigation work or water sector was under the authority of Government of India, centralized control, total. And Government of India and the Secretary of State in London exercised all the powers. Though actual work was executed by the provincial governments or the state governments. Then after 1921, there was a lot of agitation, movement from the Indian people for giving more and more power to the provincial governments. After that, diarchy was started. You must be knowing this name word called diarchy, by which some authority was given to the provincial government. And at the provincial level, there were two type of subject: reserved subject and transferred subject. Even after 21, water sector was given to the provincial list, but still it was kept as a reserve subject. That means full authority was not given to the provincial governments to work on it. Okay, the expenditure on irrigation development was not voted by the provincial legislature. That means the total control on the water sector was exercised by the governor in council, provincial governor. Even for works costing more than 5 million rupees, it was to be done with the approval of Secretary of State in London. But if you see a very important aspect, that hydropower became a transferred subject in 1921. Water remained a reserved subject, but hydropower became a transferred subject, and all powers of hydropower were given to provincial government. Now the next thing, so before 21, 2137 was one aspect. Then in 37, Government of India Act 1935 was implemented. As per this act, the whole business of the government was divided in three lists: union list, or at that time it was called federal list, provincial list, and concurrent list. And atom number 19 of this read water, that is to say water supplies, irrigation, canals, drainage, embankment, water storage, and water power. By this one single sentence, the whole water sector was given within the jurisdiction of the state government in 1937 itself. Okay, so this is very important development. That means water, when we say water is a state subject, it happened not only after constitution was accepted, or Indian constitution, but well before it, 1937 only, the water became a state subject. Then what about the interstate water disputes or interstate rivers? Even in this act, there was a provision that Governor General of India will be the deciding authority in respect of any dispute about interstate rivers. Okay, so authority for resolving the interstate dispute was given to the Governor General, was in the hands of Governor General. He could have appointed a commission to look into the matters and so on and so forth. Okay. So when you see the next slide, you can see the last sentence. The Governor General was empowered to give a decision in the matters of interprovincial or interstate water dispute referred. So for about 10 years, 13 years, 37 to 50 till we adopted our constitution, this situation remained. Then came, so we can clearly see how the water legislation and hydropower legislation developed over a period of time, before independence and after independence. So before 21, it was a full control. Then 21 to 37, it was given to the state government, that is the provincial government, but it was a reserved subject. 37 to 50, it was included in the provincial legislative list. Okay, that means it was given to the state. And after 1950, it was included in the state list. However, one additional entry was made, that is entry 56, by which the powers for interstate rivers was given to the parliament, was given to the Government of India. Okay. With respect to hydropower legislation, if you see, before 1921, it was under the full control of central government. 21 to 37, it was fully given to the state. Then 37 to 50 also, it was fully with the state. After 1950, it was included in the state list as well as in the concurrent list. Now, this is a very important difference between the hydropower and water legislation. As far as hydropower is concerned, state government can also pass the laws, central government can also pass the laws, or the parliament can also pass the laws, state legislation can also pass the laws. But in case of water, state government is having a full authority for water within its jurisdiction, except for the interstate river, for which jurisdiction is given to the parliament. Okay, so this is a major difference between the legal position vis-a-vis electricity and water. So obviously, all law passed by the central or state legislative authorities, as well as all other subordinate legislations, have to conform to the constitutional provisions. If anything is not as per constitutional provision, it will become unconstitutional and hence can be declared as illegal and inoperative. So typically how the things happen, we have constitutional provision as the basic law, fundamental law. Based on it, the state and central government or central legislative authorities passes various laws and acts. Based on and to give the effect to these laws and acts, the rules and the procedures are framed by the respective government. And then there are various departments which interpret and implement the provisions. So that is how the things happen. Now let us try to see what are the various provisions in the constitution which are there for water, so that we can understand the whole edifice of water management in India is based on those provisions. So unless we understand the constitutional provision properly, we won't be able to understand that why this is not being done by central government, why this is not being done by the state government, okay, and why government is not passing this law, why government is not doing able or is not able to do that. So all these questions will be largely answered if we see the fundamental provisions given in the constitution. In constitutional, when the Constitution of India was being framed, they could visualize that there will be issues between the central government, state government, between the various states on various matters. So they provided Article 263, whereby President was given the authority to constitute an interstate council to resolving the issue between the states and between the states and the center. Okay, so it was a general provision, but our constitutional framers also could visualize that apart from the general disputes, one area which might create difficult position or can create issues is a interstate rivers. So our founding constitutional founding fathers, they inserted a special provision called Article 262 as to how these disputes will be resolved and who will have the authority for these disputes. Okay, so Article 262 is a special provision given in the Constitution for resolving interstate disputes, and all our disputes that are happening now or which has happened earlier, whether it is a Kaveri dispute, Narmada water dispute, Krishna water dispute, Vasundhara, Mahadayi, Mahanadi, Ravi Bias, all these disputes are resolved based on the provision of this Article 262. We'll see this what that provision is. What this article says, every word given in the constitutional provision is very important because it has a bearing on the law that is going to be that is enacted by the parliament. It says Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution. Before our constitution was adopted, what was the provision in Government of India Act 1935? The provision was Governor General will be the final authority for resolution of dispute. But in our constitution, we changed it and we said that Parliament may by law provide for the adjudication of any dispute or complaint. That means the authority of resolution of dispute, and Parliament is expected to exercise that authority by making a law. Okay, this is very important. That means for any resolution of interstate dispute, the Parliament has to pass a law for it. Okay. Then what is the second clause? Notwithstanding anything in the Constitution, Parliament, again by law, that means Parliament has to pass a law to provide that neither Supreme Court nor any other court shall exercise jurisdiction in respect of any dispute or complaint as is referred in clause 1. Now this is something very important to understand, that our constitutional framers, our founding fathers, they failed that in case of water, they felt that they understood that in case of water, it is important that such type of dispute should not be resolved through judicial process of our normal sessions court, high court, Supreme Court. So this is something very important that we must understand, that constitutional provision says that Parliament by law can prohibit the jurisdiction of Supreme Court or any other court in respect of any such dispute. So there are two important articles in the Constitution. Okay. Now, has Parliament passed any law based on this? Yes. Parliament passed a law in 1956, and that law is called Interstate River Water Dispute Act 1956. And in that law, Parliament gave a mechanism as to how the interstate disputes will be resolved. Okay, we will see that as a mechanism later on. And in the same law, the Parliament also provided the Parliament in the same law it has been provided that neither Supreme Court nor any other court shall exercise jurisdiction in respect of any dispute or complaint as referred in clause 1. Now you will certainly be surprised to see that Constitution says कि Supreme Court का jurisdiction नहीं होगा. Based on the constitutional provision, there is a law which also says कि Supreme Court का jurisdiction नहीं होगा. और उसके बावजूद भी हम देखते हैं कि सुप्रीम कोर्ट कावेरी डिस्प्यूट के बारे में जजमेंट देता है. सुप्रीम कोर्ट कृष्णा डिस्प्यूट के बारे में जो भी एसएलपी फाइल होती है उसको एडमिट करता है. सुप्रीम कोर्ट जो महादई रिवर है गोवा और कर्नाटक और महाराष्ट्र के बीच में उसके बारे में एडमिट करता है. So you may find this as a discrepancy, but we will see the reason of it as we go along. But it is very important to understand that as far as constitutional provision is concerned, it gives the power of resolving a dispute to the parliament, but parliament has to exercise that power by making a law for it. Okay, that was one provision in the constitution which governs the whole interstate water dispute resolution mechanism in India. Now there is one more provision called entry number 56, which is in the union list. Now this entry says that regulation and development of interstate rivers and river valleys to the extent to which such regulation and development under the control of the union is declared by the parliament by law, again to be expedient in the public interest. That means as far as this entry is concerned, it gives the power of regulation and development of interstate rivers to the parliament, provided parliament may as a law, and that law has to be expedient in the public interest. Okay, so this is also a very big thing, because even though we say that water is a state subject, but that is applicable only for the rivers which are within a state, and most of our rivers, Ganga, Krishna, Kaveri, Mahi, Sabarmati, Narmada, Tapi, all these rivers, Brahmaputra, they are all interstate rivers because they flow from one state to other flow. And for all these rivers, the authority is already given to the parliament, not to the state government, or not to the state legislature. Then what is the problem? The problem is passing appropriate law for it, because it doesn't get applied automatically. The parliament has to pass a law. So has parliament passed any law in pursuance of this entry number 56? Yes. Parliament in 1956 itself has passed a law called River Board Act 1956. Okay, we will see that details of further. Okay. In the state list, there is a entry number 17, which has been taken from the entry number 19 of the Government of India Act 1937. वो ब्रिटिश जमाने से ही चली आ रही है, which reads water, that is to say water supplies, irrigation and canals, drainage and embankment, water storage, water power, subjected to the, but the only things that has been added is subject to the provisions of entry number 56. That means subject to the provision of 56, the full control of water will be with the state government. As I said, so there are these three important provisions in our constitution, and the whole edifice of our water management in India, water law in India, is based on three provisions. What are these three provisions? Article 262, which talks about the interstate water dispute and gives the authority to parliament. Entry number 56, which talks about the interstate water rivers and give the authority of the regulation and development to again to the parliament for passing the laws. And then article and entry number 17 of the state list, which gives the authority to state government for all issues pertaining to water. So these three entries in the constitution are the founding pillars on which the whole water management and water legislation in India is built up. Apart from these provisions, there are certain other provisions pertaining to water resources that we will see, but these three are main. As I said, for resolving interstate river water dispute, uh, Act was formulated and passed in 1956. Okay, and in this Act, it is written that the Supreme Court will not have jurisdiction in the matter. All courts, including Supreme Court, will not have matters in the jurisdiction, but still Supreme Court comes into picture. So you will surprised to know that why Supreme Court has been debarred in the first place, whereas that is the highest judicial body of the country. Why it has been barred from listening to the interstate water disputes by our founding fathers? Basically, water is a political entity, political. This one, it is not evenly distributed in space and time. It is not evenly distributed also across all sections of the society. There is a historical reasons, as I said, that during the British time, the matters of water disputes were resolved by the either governor or governor general. Secondly, the typical judicial process huge amount of time, and if these disputes are given to the judiciary, then it is likely that it will take a lot of time to resolve, and during that period the development of that particular area will suffer. Secondly, the judiciary works on a given principles or framework. Now, say for example, in case of property disputes, there are clear, conventions or rules as to how the property will be divided. Okay, but in respect of water, if there is a river flowing between two states, how that water will be divided between the two states, there is no clear-cut guidelines. How the Supreme Court will give a judgment based on it? Okay, because the judgments are given based on laws or certain conventions. But in case of water, there is no standard rules or guidelines or formulas as to how the things will be shared. Okay, it depends on so many other factors also. And as I said, water is a dynamic in nature. Whatever is available today may not be available tomorrow. There are so many ambiguities and factors that come into play. So it is not really a judicial process which can resolve these issues. So our founding fathers thought that it is better that it is left to the parliament to resolve the issues. So let parliament enact appropriate laws for resolving such certain issues in a time-bound manner. And that is how the provision came into place. And it is not that only in India the Supreme Court or the court does not have a jurisdiction. In other nations also, it is increasingly felt, and it has been there in their system also, that courts normally do not get entangled into the issues of water distribution. It's more or less a political decisions, and they are taken by the executive by having some fact-finding mission, by some commission, by some tribunal. So a specific body is created, and whatever the decision that body gives is binding on everybody. A remark by USA court, United States of American court, is very appropriate to understand why Supreme Court has been not given jurisdiction. It has said that the reason for judicial caution in adjudicating the relative rights of the state in such cases means in disputes, is that while we have jurisdiction over such disputes, they involve the interest of quasi-sovereigns, present complicated and delicate questions, and due to the possibility of future change of conditions, necessitate expert administration rather than a judicial imposition of a hard and fast rule. We say of this case, as the court has said of the interstate differences of like nature, that such mutual accommodation and agreement should, if possible, be the medium of settlement instead of invocation of our judiciary power. Because courts also does not have that expertise or a set of rules or guidelines which can decide the distribution of water resources. They are not in a very good position to give judgment on the such issues. Now in India, we see most of the rivers are interstate, and there are many disputes. Most of the disputes have been resolved by the respective state governments. They have a meeting, they come together, they follow an agreement, they sign an agreement, and the issue is resolved. Most of the rivers have those kind of this thing. Like say in case of Ganga, there is no any big water dispute as such, except yes, we have a Upper Yamuna river board, and there was some issue of what sharing of water between Haryana, Punjab, and this thing. But there were disputes in other rivers: Narmada, Godavari, Krishna, Kaveri, but there is no water dispute as far as Tapi is concerned. The distribution of Tapi waters among the three states, Gujarat, Maharashtra, and Madhya Pradesh, has been amicably settled. Same thing is with the Sabarmati, Mahi also. But yes, there are certain rivers where the dispute is of very big magnitude. For example, Kaveri, and it also has potential to create, law and order situation. And these disputes are then required to be resolved through appropriate mechanism. And this mechanism is defined in Interstate River Water Dispute Act 1956. What is this mechanism? This mechanism says that if a state government complains to Government of India about a water dispute with other state, then what? Then Government of India has to constitute a water dispute tribunal within 1 year and refer that dispute to it. The tribunal will have chairman, 2 members nominated by Chief Justice of India. Okay. That dispute tribunal will work like a judicial body, but it will have a time limit that within that particular time limit, it has to give judgment. This is the only case that it will be handling. Okay. Government of India may appoint 2 or more persons having a technical knowledge as assessors in giving the support to the tribunal, and this tribunal will have the same powers as civil court. So ultimately, what has happened, that Parliament has created a law which has again given a mechanism which is like a judicial mechanism only, but the only thing is it is a special mechanism with a limit of time required that can be taken by the tribunal. The tribunal has to give a decision within 3 years. It can be extended by 2 more years. So it is basically becomes 3 plus 2 up to 5 years. Then after the decision is given, the states or Government of India can seek guidance further, and then further explanation can be given by the tribunal within 1 year, and that is again extendable. So you can see it here that within 5 years the decision should come, and then after the decision is given, further guidance can be given within 1 year, and then it is again extendable. So practically what happens, the dispute resolution do take more than 6-7 years. The decision of the tribunal is to be published in official gazette. As per the law, this decision will have the same force as order of the Supreme Court. Okay. The Government of India may frame schemes and establish an authority to give the effect to the decision of the tribunal. Say, for example, Narmada Control Authority or the Kaveri River Water Authority is established as per the decision of the tribunal. The scheme will not be affected by any other law. This is also a very important provision of this law, that whatever is the tribunal decision, that decision will not get affected by any other law. So as we can see, Krishna Tribunal was constituted in 1969. It gave the judgment in 1976 after 7 years. Godavari 69 and it gave judgment in 1980. Narmada 69, 1979. And you will be surprised to know that it is not that once a tribunal gives a judgment, it is forever. Because as I said, water is a dynamic resource. The conditions changes over a period of time. So the judgment has a validity. The distribution of water given for a river has a validity of 30 years, 40 years. Okay. And after that period is over, then again there can be a tribunal further which will give further judgment based on the current situation. Like Krishna, in 1976, it gave a judgment, but you will find that there was again a Krishna tribunal in the for the past few years, and it gave judgment in I think 2017 or 2013. We'll see it in the next slide. Narmada, Ravi, Bias, Kaveri, uh, Krishna again, which was constituted in 2004. It gave the judgment in 2010. But again, there are special leave quotations, petitions filed by the states. Once Dhara Mahanadi is presently going on. So every time there is a dispute, the government of India, as per this act, frames the tribunal and the matter is referred to the tribunal. So you can see the map of India and the tribunals for various rivers like Ravi, Bias, Mahanadi, Vansara, Krishna, Godavari, Kaveri, Mandovi River, and Narmada River. Even though the act was passed in 1956, the act has been amended from time to time to take into account certain issues. The latest amendment was done in 2002, and one current amendment is undergoing, which has already been passed in Lok Sabha. We'll talk about it later. Now the contradiction which we were talking about, that Constitution says that Supreme Court can be barred. Parliament passed a law that yes, Supreme Court is barred, and still Supreme Court takes the cognizance of the various SLPs that the states file. What happens is, when a tribunal gives award, it is most likely that either a state is unhappy, or both the states are unhappy, or all the three states are unhappy. Nobody is happy. Or it may be basically because of the political situation in the state that forces the state government to go to the court and not to accept the tribunal judgment. Though it is compulsory by law for the state government, but it is not politically. It may not be politically convenient for the state government to accept the judgment, and they either try to, approach the Supreme Court with the special leave petitions. And the route that is adopted by is Article 131 and Article 136 of the Constitution of India. Now, what are these articles and how these articles allow the state government to approach the Supreme Court, and how these articles allow Supreme Court also to admit these petitions, even though the Constitution and the law says that Supreme Court will not have jurisdiction. Article 131 says that Supreme Court will have a original jurisdiction for any dispute between Government of India and states, or between states and two or more states. The Article 131 also says that Supreme Court shall have no jurisdiction in case of dispute relating to or if the jurisdiction is barred by any treaty, agreement, engagement, or the like. Okay. So if there is any treaty with the external other country, agreement with the other country, and if that agreement bars the jurisdiction of the court, or if there is an agreement between the states also, and if that agreement says कि Supreme Court का इसमें jurisdiction नहीं होगा, तो Supreme Court का jurisdiction नहीं होगा. And it applies to many agreements, basically because आप देखेंगे कि बहुत सारे स्टेट गवर्नमेंट के बीच में इंडिपेंडेंस के पहले ही कुछ एग्रीमेंट्स हुए हैं, उस एग्रीमेंट के भी केस में सुप्रीम कोर्ट का जुरिस्डिक्शन नहीं चलता है बिकॉज ऑफ दिस पर्टिकुलर एग्रीमेंट. बट जो ऊपर मैंने ग्रीन कलर में जो चीज देखी है कि फॉर ए डिस्प्यूट बिटवीन एनी स्टेट सुप्रीम कोर्ट विल हैव ओरिजिनल जुरिस्डिक्शन एंड सुप्रीम कोर्ट सेज यस as per this article we have a original jurisdiction and we will try to, and that is how they accept the argument of the state government and the SLPs are accepted. Article 136 says that Supreme Court may in its discretion grant SLP or grant special leave to appeal any judgment, decree, determination, sentence, order in any cause or matter passed by, made by court or tribunal in the territory of India. Now what happens now? These two things are contradictory. आर्टिकल 136 देश कि ट्राइब्यूनल का डिसीजन के अगेंस्ट भी आप सुप्रीम कोर्ट में जा सकते हैं और इंटरस्टेट वाटर डिस्प्यूट एक्ट बोलता है कि सुप्रीम कोर्ट को जुरिडिक्शन नहीं है. Is it not? There are two contradictory provisions in the constitution itself. Okay, but because finally whatever is there in the constitution, whatever is there in the law, who is the final authority to interpret it? It is the Supreme Court has the final authority to interpret it. So Supreme Court has interpreted that in spite of the debarment of the Supreme Court has interpreted that they have the authority to entertain such SLPs and they have the authority to set it right. That means if the tribunal has not acted appropriately, if the tribunal has not done its job correctly, and if there is any grievance of the state against it, then Supreme Court is the only court competent to set it right and direct the tribunal to entertain such application and decide the same on the merits. Okay. Other observation is also very interesting. It says the tribunal is a statutory authority constituted under the act made by the parliament, and this court has the jurisdiction to decide the parameters, scope, authority, and jurisdiction of the tribunal. Okay, that means Supreme Court is saying that it has a higher jurisdiction than the tribunal, and it has a jurisdiction over the decision of the tribunal also. Okay. So with these observations, Supreme Court has admitted the SLPs, special leave petitions, and it has reviewed the decision given by the tribunal. The case is Kaveri. In case of Kaveri, whatever distribution was done by the tribunal, the Supreme Court made a slight change in that, and they give additional water to the Karnataka state, maybe about 14 or 15 TMC water, small fraction, but yes, they did made some change to the decision of the tribunal. Now at present, Krishna Water Dispute Tribunal decision is again at the door of Supreme Court. The SLPs has been filed by Maharashtra, Karnataka, and those have been accepted by the Supreme Court. And then now the people are awaiting the judgment of the Supreme Court. I will skip some of the slides. Okay, so that is the position about the Interstate Water Disputes Act. So as it stands today, tribunal will give the judgment. If the state is not satisfied, they will file the SLP in the Supreme Court, and then SLP will give, Supreme Court will give you the final decision. That is how the things stand today. What about the entry number 56 in the Constitution, whereby Parliament was given the power to frame laws about the interstate rivers? That means regulation and development of interstate rivers. Yes, the act was passed by the Parliament in 1956 only, and it is called River Board Act. It is an act to provide for the establishment of river boards for the regulation and development of interstate rivers and river valleys. Now, this act is an act which is only on paper. You will be surprised to know that in spite of this act, not a single river board has been constituted in India based on this act. Basically because this act was framed in such a way that the river board, which was to be framed for development of that river basin, was given a role of only advisory consultation role. they were not given the real power that is required to push through the development of interstate rivers. The boards were supposed to consult state on each and everything. They were supposed to take advice of the state government, and that is why not a single board was constituted, and this law, this act remained only on paper. So I will skip through the slides. But you will come across certain names of the river boards like Damodar Valley Corporation, Betwa River Board, Brahmaputra Board, Tungabhadra Board. Then you will say, sir, ये boards कहाँ से आए? ये तो they are also river boards. But let me tell you that these boards are not based on the River Board Act 1956. These boards are based on the interstate agreements between the two states. So, for example, say there is a Tungabhadra board. So, Andhra Pradesh and Karnataka agreed for the development of Tungabhadra river, and they said that this development will be seen by a board which will be administered, which will have certain, certain constitution and chairman, deputy chairman, so on and so forth. So, these boards where are the offshoots of interstate agreements. They are not based on the law of the parliament. Like Narmada Control Authority, it is based on the decision of the Narmada Water Dispute Tribunal. Similarly, Kaveri Water Management Authority at number 11, it is also based on the Supreme Court decision which it was delivered in 2018. Okay. Similarly, there is a Godavari and Krishna River Management Board. This river board came into existence basically because of Andhra Pradesh Reorganization Act. When the state was divided into Telangana and Andhra Pradesh, it was decided that it was given in that act that Godavari and Krishna River Board will be constituted for management of the projects and waters of these rivers as far as Telangana and Andhra Pradesh is concerned. So we saw that there are three fundamental things in our constitution. Based on Article 262, there is the Interstate Water Dispute Act, and all our disputes are governed or resolved accordingly. There is an entry 56, but till date that entry has not been used because the act which was framed on that entry has not created any board. So entry 56 as of now has not been used. Then state government has passed various laws for its own water that is under entry 19 of the state list. Okay. So apart from these three things, there are other provisions in the constitution pertaining to water. You must be knowing that constitution gives us the fundamental rights. Right to life and personal liberty is one of such right guaranteed under Article 21. But right to drinking water is not explicitly given in the constitution. But even though that particular right is not there in the constitution, the courts have interpreted that अगर आप किसी को पानी का पीने का पानी नहीं देंगे, how the person is going to survive, how he is going to enjoy his life, right to life, is it not? So right to life inherently includes right to drinking water. Okay, so it is now well established that even though right to water is not a fundamental right written in the constitution, for all practical purposes, it is a fundamental right. Okay, then our constitution also guarantees equality before law and equal protection under law. Okay, so that means everybody will have a equal access to water, that is given. Okay, then our constitution guarantees non-discrimination on the ground of religion, race, caste, sex, place of birth, etc. So as far as water is concerned, the same will apply for use of wells, tanks, bathing ghats, rivers, with they are wholly maintained wholly or partly out of the state funds or dedicated to the use of the general public. It is not talking about the private tanks or private wells, but the wells which are maintained wholly or partly out of the public funds or which are dedicated for the public use. There, everybody will have a equal access and no discrimination. Then directive principles of the state policy says that ownership and control of the resources should be in the hands of the community to serve the purpose of all. Water is also included there. Okay. It also gives the important fundamental duties on everybody of us. Okay. जैसे मॉर्निंग के सेशन में हम जब बात कर रहे थे वाटर रेट की, तो हम कहते हैं कि जब पानी फ्री में मिलता है तो लोग वेस्ट करते हैं, बट हमारी ये फंडामेंटल ड्यूटी है कि हमें उसको प्रोटेक्ट करना है, कंजर्व करना है. हमारा नेचुरल एनवायरनमेंट है विच इंक्लूड्स फॉरेस्ट, लेक्स, रिवर्स एक्सेट्रा, उसको हमें कंजर्व करना है. एंड even though there is no water rate in that area also, it is a duty upon everybody to conserve water. There are certain provisions in the concurrent list which have some linkages with the water. 11th schedule of the Constitution of India, where powers of panchayat has been given. Lot of power has been given by the Constitution to the panchayat for management of water, which includes minor irrigation, watershed development, powers for drinking water, roads, culverts, bridges, ferries, waterways, and maintenance of community assets. Similarly, powers for the municipal corporations have been given in respect of water supply of domestic, industrial, and commercial purposes. Now, many times it happens that every state government has its own priorities. Okay. And state government does not take initiative, and then people look up to the central government that okay, central government क्या कर सकता है इस बारे में, ग्राउंड वाटर के बारे में सेंट्रल गवर्नमेंट क्या कर सकता है, इंटरस्टेट रिवर्स के बारे में क्या कर सकता है, फ्लड के बारे में सेंट्रल गवर्नमेंट क्या कर सकता है. Is there any way by which parliament can pass laws in respect of subject which are otherwise are in the jurisdiction of the state government? Yes, it is possible. So always whenever central government tries to frame a law, it tries to find out which article they can use in the from the constitution by which the law can be framed and passed in the parliament. Okay. So article 249 says that if Rajya Sabha passes a resolution by 2/3 majority, then parliament can pass law on any topic which is in the jurisdiction of the state. Then other provision is during the emergency. There is one more provision called Article 252. If two or more state legislatures pass a resolution that okay, on this subject we authorize parliament or we feel that parliament should pass the law, then parliament becomes competent to pass the law. Is there any example? Yes. The Water Pollution and Prevention Control Act of 1974 is a classic example that a law pertaining to the water has been passed by parliament even though it is within the jurisdiction of the state government. Why? Basically at that time, two state governments, I think it was Karnataka and probably West Bengal, Odisha, they passed resolution in their state legislature that okay, we authorize central government to pass the law for water pollution. So the parliament passed the law, so it became applicable to those two states. But then later on, every state government passed a resolution in their state assembly that okay, we will accept the law passed by the parliament. So accordingly, every state accepted it, and by 1990, that law, which was passed in 1974, become applicable to every state. That is one way of doing it. Okay, that means state government willingly tells parliament to pass the law. The other way is parliament's power to legislate to give the effect to the international agreement. If government of India accepts any international agreement and to give the effect to that agreement, if it has to pass a law which is otherwise is in the state's jurisdiction, parliament still can do it. That is Article 250. So has parliament done any passed any law using this one? Yes. Environment Protection Act, जो आप लोगों ने काफी सुना होगा, उस एक्ट में बहुत पावर पार्लियामेंट ने सेंट्रल गवर्नमेंट को दिया है. ये जो एनवायरमेंट प्रोटेक्शन एक्ट है, आप सबको और भी एक याद होगा, एनवायरमेंट ये वर्ड कहीं पर भी हमारे कॉन्स्टिट्यूशन में नहीं है। ये जब हमारी भोपाल की गैस ट्रेजेडी हुई, भोपाल की गैस ट्रेजेडी के बाद गवर्नमेंट को लगा कि पोल्यूशन या एनवायरमेंटल कंट्रोल के लिए हमें सख्त कदम उठाने होंगे, और हमने यूनाइटेड नेशन का जो स्टॉकहोम डिक्लेरेशन है उसके हम सिग्नेटरी है। यूएन चार्टर जो है स्टॉकहोम डिक्लेरेशन फॉर रिगार्डिंग एनवायरमेंट। So to give the effect to that declaration, the Parliament passed Environment Protection Act. So Article 253 is used for passing that act. Okay. Then Article 356 is also one way by which Parliament can pass a law. Why we are discussing all these? Because many times we say कि सेंट्रल गवर्नमेंट इसमें कुछ क्यों नहीं कर रहा, सेंट्रल गवर्नमेंट इसमें कोई कायदा क्यों नहीं लाता, कानून क्यों नहीं लाता। बट उसका रीजन ये है कि सेंट्रल गवर्नमेंट अगर कोई पार्लियामेंट अगर कोई कानून लाता भी है तो वो कानून कॉन्स्टिट्यूशन के अकॉर्डिंगली होना चाहिए, एंड इसीलिए वही कानून हम ला सकते हैं जो कॉन्स्टिट्यूशन के अकॉर्डिंगली। हमारी जो मिनिस्ट्री ऑफ जल शक्ति है ये 5 नए कानून पे काम कर रही है, उसके बारे में भी हम तो शॉर्टली डिस्कस करेंगे, और वो कानून अब तक क्यों नहीं बने तो उनका क्या अभी स्टेटस है वो भी हम डिस्कस करेंगे। There are other provisions also. आप यहाँ पे देख सकते हैं कि हमारे जो पानी के रिलेटेड जो कानून हैं वो किस किस बेसिस पे बने हैं। इंटरस्टेट रिवर वाटर डिस्प्यूट एक्ट आर्टिकल 262, रिवर बोर्ड एक्ट आर्टिकल 246 एंड एंट्री नंबर 56, वाटर प्रिवेंशन एंड कंट्रोल ऑफ पोल्यूशन एक्ट ये आर्टिकल 252 के बेसिस पे बना। देन एनवायरमेंटल प्रोटेक्शन एक्ट आर्टिकल 253 के अकॉर्डिंगली बना। इंडियन इजमेंट एक्ट 1982 का एक ब्रिटिश जमाने का एक्ट है, आपको जानकर हैरानी होगी कि ब्रिटिश जमाने का ये एक्ट अभी भी भारत में लागू है, क्योंकि हमारे कॉन्स्टिट्यूशन में जो एक आर्टिकल 372 है जिसके अकॉर्डिंगली इंडिपेंडेंस के पहले की भी कुछ कानून हमने बाद में लागू किए, उसमें एक ये इंडियन इजमेंट एक्ट है। इसका भी बड़ा इंपॉर्टेंस आज भी है, वो क्यों इंपॉर्टेंस है हम देखेंगे। आई विल हाँ, ये इंडियन इजमेंट एक्ट जो है ये एक्ट बेसिकली ग्राउंड वाटर को जमीन के साथ जोड़ता है। दैट मीन्स अगर मैंने इफ आई सेल माई लैंड टू समबडी, दैट मीन्स आई एम नॉट ओनली सेलिंग द लैंड बट आई एम ऑल्सो सेलिंग द ग्राउंड वाटर एसोसिएटेड विथ इट। दैट मीन्स जिसका लैंड उसका ग्राउंड वाटर। ओके, सो दैट्स व्हाई एज पर दिस एक्ट the owner of the land gets full right to extract the groundwater. But there is a slight restriction on it. This act states that the right of every owner of the land to collect and dispose within its own limits of all the water under the land which does not pass in a defined channel and all water on its surface which does not pass in a defined channel. इसका मतलब ये है कि इस कानून के तहत अगर मेरा कोई जमीन है और जमीन के बीचों बीच एक अगर कोई छोटा सा वाटर बॉडी बना हुआ है और उसमें पानी जमा हुआ है जो फ्लो नहीं हो रहा, तो वो पानी मेरा। जमीन के नीचे जो स्टेडी पानी है जो फ्लो नहीं हो रहा जमीन के नीचे भी, वो पानी मेरा। बट अगर जमीन के नीचे अंडरग्राउंड स्ट्रीम है, अंडरग्राउंड फ्लो है, तो वो पूरा पानी मेरा नहीं हो सकता। या मेरे खेत में से कोई स्ट्रीम जा रही है, कोई झरना जा रहा है, कोई नाला जा रहा है, तो पूरा के पूरा पानी मेरा नहीं हो सकता। Now it is easier to quantify the stream or the flow of water above the ground. सरफेस पे करना तो आसान है, बट जमीन के नीचे पानी फ्लो हो रहा है कि नहीं हो रहा है इसको एस्टैब्लिश करना बड़ा मुश्किल है। एंड दैट इज व्हाई application of this law for the groundwater has really become very difficult, and people are drawing the water as much as they want. काफी समय से ये सिविल सोसाइटी की भी डिमांड रही है, एनजीओज की डिमांड रही है, वाटर रिसोर्सेज के जो प्रोफेशनल्स हैं उनकी भी डिमांड रही है, बिकॉज वाटर इज अ स्टेट सब्जेक्ट और कॉन्स्टिट्यूशन के प्रोविजन के अकॉर्डिंगली हमारी जो लीगल प्रोविजन है वो अभी बहुत स्ट्रांग नहीं बनी है। तो एक नेशनल वाटर फ्रेमवर्क लॉ होना चाहिए जिसमें सभी गवर्नमेंट को, चाहे सेंट्रल हो, स्टेट हो, जिला परिषद हो, कॉरपोरेशन हो, everybody should work in a focused way, in a unified way towards water management. तो एक अम्ब्रेला स्टेटमेंट होना चाहिए और वो अम्ब्रेला स्टेटमेंट केवल पॉलिसी के फॉर्म में नहीं हो, क्योंकि पॉलिसी तो जस्टिसाइबल नहीं होती है. पॉलिसी some follow, some doesn't follow. It should be a law so that everybody should follow it, and any violation of it should be punished. So Department of Water Resources, Ministry of Jal Shakti, or former Ministry of Water Resources, started working on this law, and this law has gone through many iterations, many modifications. सबसे पहले 200 सबसे पहले Shri he was the chairman of the committee who drafted the bill. Then Dr. Mihir Shah committee was given a task of modifying the draft. That draft has been circulated to all the state governments for their consultation, for their remarks. You'll be surprised to know that any initiative by the central government to enact law in water sector is normally opposed by the state government, because they feel that central government is trying to encroach upon its jurisdiction. Same thing has happened in respect of this law. Government of Rajasthan, Madhya Pradesh, Uttar Pradesh, Maharashtra, Gujarat, Jharkhand, they have supported this bill, but they have given certain comments, suggestions, modifications. However, Tamil Nadu, Kerala, Karnataka, Punjab, Odisha, Bihar, they have not supported, rather they have opposed the bill, saying that this bill is not required. We have our own powers and we will use our own powers. The bill is under examination in Uttarakhand, Arunachal Pradesh, Delhi, and Lakshadweep. So, passing a law by the parliament pertaining to water sector is not easy. It requires consensus of all states. It requires proper use of constitutional provisions. Otherwise, there is a possibility that after the law is passed, the Supreme Court may declare it as unconstitutional, basically because it is not as per the constitutional provisions. So before passing a law, the ministry, the government, the parliament has to ensure that the law is legally proper. So they are exploring, the Department of Water Resources is exploring how to pass this law. Already states have been requested to give their consent, and if more than 2 states give the consent, then it can be passed, but then it will be applicable only to the states we have consented it. Then other states can join later on. The law can be passed under Article 253 to give the effect to some international agreement. We are party to the United Nations Sustainable Goals, and if the law is for giving the effect to the provisions of the Sustainable Goals, then it can be passed under this Article 253. That is also one way of doing it. So that is a one legal initiative that is being taken by the Department of Water Resources, Ministry of Jal Shakti, and let us hope that it goes through. That will strengthen the legal position of water resources in the country for better water management. The other act which is in the pipeline is a River Basin Management Bill. We saw that River Board Act is of no use. Nothing has been done under that act. So this new bill is being formulated by the central government. Obviously, this bill will be passed under entry 56. So not really, it requires the consent of the state governments. But because we are a federal, democracy, we still try to gauge, try to take all the state on board. So this draft has been prepared. This draft has been prepared by a committee headed by Justice Tejinder Singh Dobia in 2012. Then a group of officers headed by Shri A.B. Pandya, former chairman CWC, to make further modifications and changes. And now this final draft is ready. This draft proposes to establish 13 river basin authorities like Ganga, Tapi, Narmada, Kaveri. Okay, and these river basin authorities established by under this act will work for the development and regulation of these rivers. But again, the state governments are not very enthusiastic about this, and they are raising their opposition and apprehensions, and that is why there is no consensus for passing of this bill, and it is not yet been presented to the parliament. There is a third important bill that is under process, which is already been passed by Lok Sabha, and that is called Dam Safety Bill. This dam safety bill has been passed by the parliament, not by parliament, by Lok Sabha, under the entry number 97, which gives the power to the parliament to pass laws in respect of subjects which are not there in the all the three list. क्योंकि कोई ऐसी नई चीज हो सकती है कि जो लिस्ट 1 में भी नहीं, 2 में भी नहीं, 3 में भी नहीं, यूनियन लिस्ट में भी नहीं, स्टेट में भी नहीं और कंकरेंट लिस्ट में भी नहीं. तो डैम सेफ्टी एक ऐसा इशू है जो जिस समय हमारी कॉन्स्टिट्यूशन बनी उस समय नहीं था. तो पार्लियामेंट हैज जो सारी रिसिडुअल पावर है, रिसिडुअल पावर है कि जो टॉपिक उसमें नहीं दिया उस टॉपिक के बारे में पार्लियामेंट लॉ कर सकती है. 97 हमारा जो 97 जो ये है आर्टिकल है उसके तहत ये बिल लोकसभा में पास हुआ है. ये बिल इसलिए पास करना पड़ा या ये लॉ इसलिए बनाया है क्योंकि हमारे देश में वी हैव मोर देन 5000 लार्ज डैम्स. सम ऑफ द डैम्स आर ओल्ड 100 years, 50 years. Now these old dams needs proper maintenance because these are the structures very important for our population, for irrigation, for domestic purposes, and these structures are also required to be maintained properly. They are required to be inspected properly. They are required to be monitored properly so that there is no damage to them and there is no issue of any safety arising out of this old this one. So all the dam owners, whether it is a state government, whether it is a corporation, whether it is any other body, they have to be given a legal role, legal responsibility to ensure the safety of the structures. So this law basically ensures that the dam authority will be responsible for the dam safety, for its inspection, for maintenance, proper budget for it, proper personnel for it, proper instrumentation for the dam. And that is why this bill has been prepared by the Ministry of Jal Shakti. It has been passed by the cabinet. It has been passed by Lok Sabha, and now it is going to be presented to the Rajya Sabha. And we are hoping that with this bill becoming an act, the dam safety in our country will be more strengthened and appropriate actions will be taken by the state government, by the dam owners to maintain the dams. And if they don't take that action, the act will make them liable to pay penalty or to face consequences for it. It was passed in the Lok Sabha on 2nd of August. The next important bill that is going to be that is being processed by central government is मॉडल ग्राउंड वाटर बिल. जैसे मैंने कहा कि इजमेंट एक्ट के तहत जिसका लैंड उसका पानी, और पानी भी स्टेट गवर्नमेंट के जुरिस्डिक्शन में आता है और लैंड भी जुरिस्डिक्शन में आती है. तो ग्राउंड वाटर के बारे में यूज के बारे में सेंट्रल गवर्नमेंट बहुत ज्यादा लॉ पास नहीं कर सकता है. सो व्हाट दे हैव डन इज दे हैव क्रिएटेड ए मॉडल एक्ट and they have circulated it among all the state government, and they have told that you please get this model bill approved in your respective state legislature so that it becomes a law. Okay, this law, this model bill was first framed in 1970. It was revised later on. A committee under Dr. Mir Shah finally drafted a latest bill that is called Model Bill 2016. It is in the public domain now, and this bill is given to the state governments for further implementation. further passing in their legislature and then further implementation. The last one initiative that we are going to talk about, which is has been taken by Minister of Jal Shakti, is regarding वाटर डिस्प्यूट ट्राइब्यूनल. हमने पहले ही देखा कि वाटर डिस्प्यूट ट्राइब्यूनल का प्रोविजन है इंटरस्टेट वाटर डिस्प्यूट एक्ट 1956 में, बट उसमें एज पर दैट एक्ट every time there is a dispute we constitute a new tribunal. Then what happens, that tribunal has to be given space, it has to be given office and so on and so forth, so it takes time. And then that tribunal has been given 5 years, 3+2, which is a longer period, certainly. So as per the new provision, that time is being reduced. There will be a permanent tribunal. So whenever there is a dispute, that tribunal will be immediately given that dispute to tackle. The tribunal will have a number of benches. Okay, so it will be a permanent institution, and the time period is reduced from 3+2 to 2+1. Secondly, it will not be required that the award of the tribunal is published in the newspaper, published in the gazette, sorry, not in the newspaper, gazette. Automatically it is assumed to be published. Okay, there is a provision of dispute resolution committee also, that before a dispute is given to the tribunal, a dispute resolution committee is constituted and they will try to resolve the dispute. Only if they fail, then only it goes to the tribunal. Okay. This amendment, which is the latest amendment to that act, which is expected to fast or speed up the process of dispute resolution, has been passed by the Lok Sabha on 31st of July 2019, and the bill is now to be considered by the Rajya Sabha. So these 5 are the legal initiatives taken by central government, and we can expect that with passing of these 5 laws, the water management or water governance in India will be much better. Thank you so much. I have taken slightly more time, but I hope I was able to cover most of the points that are important. Yes, it is because they are legal issues, but they are the foundation of the whole water management. That's why we thought that you are people from media, you give reports, you form public opinion, and I'm sure that you will appreciate the initiatives taken by the central government in bringing the sea change in the water governance in the country, and we require support of the state government for these legal initiatives so that they actually becomes law, and then we are able to do the water management in a better way. So thank you very much.